Hello, my name is Lance Jones. I'm a partner in the law firm of Hepler Broom. I'm here today to talk to you a little bit about the new rules for overtime under the Fair Labor Standards Act. Hepler Broom is a law firm that has existed for a number of years. We have offices in Edwardsville, Chicago, Springfield, and Crystal Lake in Illinois, and we also have offices in St. Louis. So we cover Illinois and Missouri, along with many other states. We have a very varied, wide practice in litigation that includes employment law, commercial litigation, toxic tort, products liability, construction litigation, and just a multitude of other areas of practice. It's been in existence for a long time. We have approximately 135 attorneys who serve clients in over 30 practice areas in those 6 offices. This is a little bit about me. I've been a trial attorney since 1984. I've practiced in employment law for my entire career, along with some other areas of especially construction and personal injury, things of that nature. Jessica Lanos is a superstar associate in our firm, and she's helped put this presentation together. Just a little overview. This presentation will discuss the changes to the federal rules regarding the payment of overtime compensation to employees. As many of you probably already know, certain employees are entitled to receive overtime compensation under federal law and state law. Federal law is called Fair Labor Standards Act, or the FLSA. In general, the FLSA requires that certain employees receive overtime compensation for time worked in excess of 40 hours per week. This may vary depending on the type of job or work schedule. The U.S. Department of Labor issues rules under the FLSA that govern overtime compensation and other issues, including minimum wage, etc. Of course, overtime compensation is paid at the rate of 1.5 times the regular hourly salary. Many of you may have heard of the concepts or the classifications of exempt and non-exempt employees. An exempt employee is an employee that an employer is not required to pay overtime, so they're not entitled to it. An employee that is non-exempt, overtime is required for any hours worked over 40 hours in a work week. There's been a number of changes to the overtime. This presentation will discuss the changes as a result of change in the salary level for what are called white-collar classifications, executive, administrative, and professional employees. This, of course, is not the only change to the overtime rules that may impact your business. If you think your business may be impacted by the new rules, you should seek legal advice to address these issues. Some other areas of rules that I'm really not going to discuss today relate to bonuses and incentive payments. Now employers will be allowed to use non-discretionary bonuses and incentive payments and commissions toward as much as 10% of the salary threshold that applies under the FLSA. There's also, it also raises the total of annual compensation for highly compensated employees from $100,000 to a little over $134,000. In March 2014, President Obama instructed the U.S. Department of Labor to update the regulations. The Federal Department of Labor adopted or updated the rules regarding overtime compensation in May 2016. It's important to note that these rules take effect on December 1, and employers must be in compliance at that time, or they may be subject to civil fines or penalties. The change came about in part because of a narrowing gap between hourly employees who receive minimum wage and white-collar employees that are executives and administrators and things of that nature. Under the current overtime laws, a manager, for example, might make more money working as a lower level wage employee who receives overtime compensation than he does working as a manager. Of course, that's because as a manager he doesn't receive overtime when he works more than 40 hours. We've all probably heard white-collar classifications here: executive, administrative, and professional employees that are currently exempt under the overtime laws, under these new rules, may be entitled to overtime compensation under the new rules. The salary level is a basis in which if an employee exceeds the threshold of the salary level and they're appropriately classified as executive or administrative or professional, they may be exempt from overtime laws. This level currently is at $450 per week, which amounts to $23,660 annually. Right now, if these employees earn more than $23,600 annually, they are exempt from the overtime requirement and are not required to be paid overtime. However, under the new regulations, the salary levels increase quite very much. Now it's $450 per week. It's being raised to $913 per week, which amounts to $47,476 annually. So what this means is that you may have certain mid-level employees and managers who work more than 40 hours per week that make between $23,660 per year and $47,476 per year that may now be entitled to receive overtime compensation. This requires employers to go back and look to see if certain employees need to be reclassified as non-exempt, as they would now be entitled to overtime compensation. Under the new rules, the U.S. Department of Labor has instituted a 3-year automatic update for these salary and compensation levels. The U.S. DOL has set the salary level at the 40th percentile of full-time salaried workers in the lowest income region of the country. So now that we know that employers are going to be impacted by these new rules, here are some suggestions as what you might do to bring yourself into compliance by December 1. You can conduct an FLSA audit. You can consider what options you have for those employees that were exempt that may now be non-exempt. You're going to have training. We would recommend training of newly non-exempt employees. And of course, you need to communicate with your workers. Now, these are just suggestions. They're not intended to be legal advice. These issues are very, very fact specific and should be done with the advice of legal counsel. The first option we suggested was to conduct an FLSA audit of exempt employees to determine whether or not they may lose their exempt status and be entitled to overtime. This audit may provide employers with an opportunity to correct past classification mistakes. For example, an employee might be making $30,000 a year, not receive overtime, but really didn't meet the duties test for being an exempt employee as an administrative, executive, or professional employee. So this change in doing an audit may actually turn out to be a blessing because you can correct those errors and not be subject to penalties under the Act. The second suggestion was to consider options. There may be a number of different options that are available, and it kind of depends on your particular business. We again recommend you seek legal advice and exploring these options to ensure compliance. One option is just to increase the salary. You may have an employee that is close to the $47,000 threshold, and it may be better to just raise the salary than to allow him to work overtime for hours in excess of 40 hours per week. A second option might be to limit the time worked. It may be better just to limit the hours of the newly classified employee in order to avoid having to pay him overtime. This largely depends on what the employee is required to do and whether he can get his work done in 40 hours per week. This may also require hiring part-time employees to avoid having newly non-exempt employees work more than 40 hours per week. A third option is to convert exempt employees into hourly workers. It may be advantageous to drop the hourly rates of the newly exempt employees so that when they begin receiving overtime compensation, the hour and a half or working those overtime may average out to be comparable to the salary that they're already receiving. There's a caution, an employee may see this as a pay decrease or demotion, and that may cause for some problems with the employee. A third suggestion that we can talk about is training newly non-exempt employees. As I mentioned earlier, there are record-keeping requirements under the Act, and so the newly non-exempt employees that didn't have to keep time-keeping records before will have to be brought up to speed on the methods to be used. One caution here is that employers often have a policy that requires prior authorization before working overtime. Just having the policy may not be enough. If an employer routinely assigns work to a non-exempt employee that cannot be completed in 40 hours a week, but then turns a blind eye when those non-exempt employees actually work 40 hours a week, they may be violating the FLSA. In other words, an employer just cannot hide behind the policy. They need to make sure and be vigilant that the non-exempt employees are following the record-keeping requirements, working overtime, being compensated for it. A fourth suggestion would be communicate with your employees, which is always a good suggestion. Explain why the changes are taking place, why they need to be tracking their time, while explain to them that they might now be being paid for every hour that they work, and ensure that the HR employees are prepared to answer any questions that someone may have. The importance of complying with the FLSA is because there are a number of civil and criminal penalties that may be involved. This includes claims that employees might bring civilly that may include past wages, and also can include, in certain circumstances, punitive damages. Willful violations may even lead to criminal charges. Employers who willfully and repeatedly violate the overtime compensation requirements may also be subject to civil penalties of up to $1,000 per violation. So, to encapsulate, do not take FLSA classification issues lightly. They can lead to criminal and civil penalties as well as legal fees and damages for employers that do not comply with the law. Just as an aside, just recently here in Springfield, a federal civil jury awarded to an employee a $300,000 punitive damage award because of misclassifications and retaliatory discharge claim. It's better to invest in the advice up front than pay those penalties and damages later. Thank you for listening to this. Again, my name is Lance Jones. You have my contact information here. If you have any questions about the application of the new FLSA rules to your company, please feel free to give me a call. Thank you.